Please, Your Lordship. Lordship, I beg to mention item number 13 with the consent of the other side, Lordship.
Item number
13, Lordship. One matter will be adjourned for 2 weeks, Lordship. I am for the respondent, Lordship.
in fact, they were to file reply.
Yes, sir. They are for the petition, Lordship.
They were to file reply. Last time it was so decided. Anyway, you want time. January. Next.
I beg to mention item number 26 and 27, my lord. My lord, today we have our senior has some personal difficulties, my lord. So, and he adjourned for 2 weeks, my lord.
2 weeks.
May I please, Your Lordship? With the consent of other side, I beg to mention for item number 49, Lordship. Kindly matter may be taken after vacation, Lordship.
Which vacation?
I am for
Which
respondent.
vacation?
Lordship,
Which vacation? Which vacation? There are 2 vacations. Have you seen the calendar?
after 20
Next.
must be.
May it please, Your Lordship. Lordship, I beg to mention item number 38, my lord. Today, my senior has some personal difficulty, my lord. Can this matter be taken up on 7th, my lord, next week? I am for the respondent number 2, my lord. I have taken the consent of the review petition, my lord.
Next week.
May I please, Lordship? Lordship, I beg to mention item number 12 of the daily list.
Item number?
1, 2, Lordship. Praying for adjournment of this matter, Lordship. Matter may be kindly adjourned for 2 weeks, Lordship.
Item 12.
12, 1, 2.
You appear for whom?
Respondent number 1, Lord.
Next week.
May it please, Your Lordship. Item number 39 of today's list, my lord. I have taken the consent of the other side.
Item number?
39, my lord. Item 39 of today's list, my lord. I have taken the consent of the other side. Can it be on 15th, my lord?
Of which month?
Of this month, my lord.
January. I have to continue. Next.
Obliged. Obliged.
May I please, Your Lord? Lordship, with the consent of the other side, I'd like to mention item number 47 of the daily list. Lordship, in this matter, Dr. Akutar has got some personal difficulty. Matter will be adjourned for 2 weeks.
Yes. Beyond vacation. Next.
Wait, please, my lord. My lord, in item number 35 of the daily list, my lord, I have filed the wakalatnama today for the respondent, my lord. So, my lord, this matter may be adjourned for 3 weeks, my lord. Council, I've informed the council for the other side, my lord.
At the request of so-and-so, the matter is adjourned. Meanwhile, CRP called for. Next. So as to receive court on or before the next date of hearing. Next.
May it please, Your
Alright.
Lordship. Lordship, I am praying for a listing of an IA for tomorrow, Lordship.
What is the urgency?
Lordship, there was an order for filing an appeal before the DRT within 15 days, Lordship. Due to the illness of the petitioner, we could not file it on time, Lordship. Therefore, for extension of time, Lordship.
Monday.
Lordship, Monday, my senior will be out of station, Lordship.
I am out of station tomorrow. What do we do? I can't permit you to appear in idle bench virtually. Next.
May I please, Lordship? Lordship, with the consent of the other side, Lordship, I beg to mention item number 34 of the daily list, Lordship. It may
Yes.
come after, Lordship, the winter vacation, Lordship.
When do you want?
After a vacation, winter vacation, Lordship.
Even otherwise, LCR has not come.
Yes, Lordship.
That's the joint request.
Obliged, Lordship.
Meanwhile, the registry is directed to call for the LCR. Next.
Maybe, Lordship. My lord, I beg to mention item number 19, 19, my lord. Here in this case, my lord, I am for the caveat, but my caveat, my lord, has not been tagged with the retapit, and my name also has not been shown in the close list.
Have you informed Mr. Mohammed?
My lord,
Have you informed the other side?
my lord, I will inform, my lord. I have sought them, but I have not got them.
You inform them and then mention the matter.
Obliged, my lord.
With the consent of other party, I have mentioned my item number 14.
Hmm.
Your Lordship, after winter vacation. 26.
Next week. There is nothing in the matter. Next week.
Yeah, please, your lordship. Lordship, item number 3 and 4, your lordship. In this matter, the learned advocate general is appearing. He's out of station today. Next week, sometime, lordship, 7th or 8th, if it is convenient for your lordship. There's some urgency in the matter, but
February. 7th
his
and 8th of February. 7th or 8th of February now.
lordship, there's some urgency 7th or 8th of December or 9th, lordship.
We have already picked one matter of Mr. Das.
9th, lordship, 9th.
We have already picked one matter for 9th. Let it come next. Give some date. Not in December. Next. Pull out.
Item number 50 of supplementary list for withdrawal.
Wait, this is your lordship. Lordship, as per the instructions of my client, I would like to withdraw this matter with liberty.
What liberty?
Lordship, I have accepted the proposal for transfer and deputation. I've already given my, I've already submitted for it.
There can be any liberty in a consent matter. Either you withdraw it or we dispose it of it. Not press on instructions. Then dismiss. Next.
Item number 1 of daily list.
May I please, your lordship, if this matter may kindly be passed over for a time being.
Mr. Sharma,
Yes, your lord.
from the affidavit, it is very clear that he purchased the property before you mortgage the property.
Yes, your lordship. It
As
is.
far as the second floor is concerned.
Yes, sir.
Now, therefore, even if by any fraud or any misrepresentation, anything is done by them, by the bank, and this the seller themselves, he should not be penalized.
No, your lordship. He should not.
This is the matter where Article 226 jurisdiction has to be exercised.
Yes, your lordship. Because
You will
we have mortgaged on first and second floor, and they are on the. We are on the ground and the first floor.
And you have taken possession of ground and first.
Yes, your lord. Yes.
There is no question.
There is
You-
no-
You make a statement that second floor will not be touched. We dispose of the matter.
Yes, your lordship. We will not touch the second floor. And in fact, we have submitted before the executive magistrate also. That
See what happens, I'll tell you. There seems to be some discrepancy in the description of the property in the schedule,
yes, your lord.
which has created this problem.
Yes, your lord.
Otherwise, different floors of different ownership is not an unknown phenomena.
Yes, your lord.
Even in cities like Delhi and other major cities where courts are there, ground floor may be belonging to one and the first floor may be belonging
Yes.
to another owner.
Yes, your lord. Actually, your lordship, in the sale deed, it has been written as on the roof of the first floor. That is why it states
See what I have noticed is that they purchased the terrace. Then they themselves have constructed the second floor. From the
Yes.
description of the property, it appears. So, and in the affidavit, they are very clear.
yes.
So you make a statement, we'll dispose of the matter.
Yes, your lordship. We will not touch the second floor of the petition.
What's your name?
P. Sinha, my lord.
Huh?
P. Sinha. On behalf of West Border.
Or your lordship, do I submit on affidavit, your lordship?
That is better. Do it by Monday
Yes, sir.
at the request of Mr. Sharma. Action to take. Next.
Item number 2.
Please, your lordship. Lord, this petition against the SARFAESI proceeding, bank has proceeded without considering my, Lord, representation. That was filed under section 13(3)A, Lord. And that about, Lord,
Go to DRT.
Lord,
Go to DRT. Kamrup Metro. It is very near.
Lord, problem is that, Lord,
Problem is that you have to make deposit.
I'm depositing, Lord.
You have to make deposit. There is the judgment of the Supreme Court. Which gets glad of.
Yes, Lord, I have gone through that.
You have only gone through, I have also relied upon, that is the difference.
Facts are little bit different,
Advocate has to argue. Has any advocate ever considered that my case is covered against me by this judgment? Ever, have you find any such advocate?
Actually, they have to consider my
That
representation.
you tell the TRT, then whatever you want to. These are all lame excuses.
One problem is there, Milord. That is,
Sir, on the contrary, if we write one sentence that there is compliance of section 3A of section 13, subsection 3 of section 13, even DRT will not touch you. Representation consider means what? They have not to call you and hear you. That's not the essence of the provision of the SARFAESI Act. These are all delay tactics.
no, I am paying, Milord.
What paying? Parking charges.
Only had they considered my,
What do you want? Do you want an order?
Milord,
Page 53 if you want to still be with us. Page 53 of the paper book. Nothing doing. This circuitous route, now Supreme Court has made it very clear. भाई वो किसी को दिया था वो वापिस नहीं लिया. Huh? That is the difficulty everywhere. I have got it in my mobile. I will take it out. What do you want?
Milord, consider my representation before
Not
taking any action, Milord.
no.
Can you have a look at Milord there?
No T20 or 1 day. We are going to lose today's 1 day for your information. Which is going on in Christchurch.
I have already filed in WPC also, in that, Milord, IIT and MNRE. In spite of completing all these things, they have admitted, but they are not releasing my money. That is the problem, Milord.
वो बात अलग है.
Near about 1 crore rupees has been.
A burden end is always worth 2 in a post counsel.
So under peculiar circumstances, your
There are
lordship.
no peculiar circumstances. These are all NPA.
NPA, Milord, what happened there? Whenever this petitioner goes to deposit the money,
भैया ऐसा कभी सुना है? आदमी अंधेरे में भी लक्ष्मी का स्वागत करता है. वो सब बातें मुझे मत बता. NPA means NPA, not to pay anybody. That is NPA. You want an order, gentlemen? We are running against time.
Milord, I leave to your lordship.
No, don't leave it to us.
Leave to your lordship.
Dismiss. Next.
Milord, with your liberty to,
No liberty. No liberty.
Milord, I shall approach there, Milord.
Then if you want to approach, you may withdraw the petition. Otherwise, we
Then, Milord, withdraw.
have the liberty to take appropriate alternative remedy available under the provisions of this SARFAESI Act. Next.
Item number 5.
Yes, Mr. Nath.
Not by order dated 29.
Affidavit.
Lord, I took time to file affidavit, but I communicated to respondent number 2. They informed me that the BTC has also communicated a letter.
Did he
They have-
communicate to you that he was at Delhi and not in
No. They have already, BTC has already directed for an inquiry.
for 1 week, all your officers can tell you that we
No,
were
no,
at
that-
Delhi.
No, that communication is not with me, Malak. But I have been told that BTC has already directed for a detailed
Whatever you
inquiry.
want to say, please file affidavit. Mr.
The inquiry is going on, Malak, and the instruction is given already to the BTC, Malak, Principal Secretary BTC.
Whoever, you file
That-
the affidavit.
Lordship. To that effect.
3 weeks. Next.
Public.
Item number 6.
Who is for the appeal? Mr. Ahmed.
I'm for the respondent railways matter.
I'm the respondent for my.
We'll pass it over. He is not here. He is not here.
For the timing, man.
Naturally for the time being, not for the day. We don't want to become anybody's mother-in-law.
Item number 7 to 11. Lordship, I am for item number 8. So 8, my lord. 7 full sum to loan
Mr. Nair, the reply was to be filed.
we have filed the affidavit. We have filed the affidavit on, my lord. We have also received, my lord.
We have also received. So do you want to file reply or we go?
They have filed the reply. I have filed.
That we have not received.
They have filed a reply. Monday, my lord.
I have already filed my lord. Reply my lord. Because what are the information providing the affidavit in opposition, my lord? We have provided better information in our my lord application during the penitential petition with the trial court after collecting materials from RTI. My yeah, they said, my lord, only 2 or 3. My lord, the respondents, the subjects found.
No, 6.
6, my lord.
6, as per their affidavit, my lord.
They are
6 submitted after cut-off.
Will show, my lord, is more than 20, my lord.
Okay. Whatever you want to file, we are not in a hurry. We don't want to take any pleadings after we dispose of the petition. Like Mr. Pathak's client.
My lord, we have filed the affidavit.
So your affidavit is there.
No, my lord, in writ appeal 308/2021.
308.
We are relying it on all other accounts.
That would be the lead man. But probably the learned counsel wants to factually.
Fine, my lord, let him answer.
The affidavit is filed by the affidavit in opposition. By respondent number 7. Is on record. Counsel appearing for the respondent. Decide to file affidavit in reply. To enable them to do so. So, give some next. 18th of January. Next.
Item number 15.
May I please your lordship. My lord, in this case, my lord, the last time I'm directed to file affidavit, but no affidavit is filed as yet. My lord.
That pension matter.
Pension matter, my lord. Well, petitioners are, my lord, retired as casual employees.
Ms. Bora, you were to file affidavit.
They have to receive instruction, lordship. Their services were not regularized, lordship.
But you file affidavit. Next week. At the request of Ms. R.P. Bora. File affidavit, it's done to make it 11th of December. We grant you more time. Next.
I realize your lordship.
Item number 16.
I am for a restaurant, madam.
We'll pass it over. He is not here. Next.
Item number 17.
May it please your lordships. Lordships, the IA is for impleadment of a party. Last time during the pendency of the appeal, a new person has been appointed as a Gaubura. So it has fallen from your lordship that that person should be impleaded. That's why this application.
So IA allow notice to newly amendment to be carried out, and in main matter notice to newly added party returnable on 23rd of January 2023. Next.
Obliged.
The IA disposal.
Item number 18.
Yes, Majmudar.
The learned single judge in this matter had directed the petitioner to approach before the to go for the appellate forum.
No, but is it an internal dispute under section 14?
They are asking, they are trying to determine who is the senior of the two.
No, but is it an internal dispute as envisaged under section 14 of that act?
My lord, in the other case, then it has to go before the tribunal.
No, you
for the evidence part.
You show evidence here.
My lord.
See, if it is a dispute between two internal disputes.
My lord.
Then the judgments are there, even our division bench has taken a
Yes.
view.
Rajat.
But this doesn't seem to be so simpliciter an internal dispute.
Number, who is the senior to get the evidence part?
That is not
Find
an
out.
internal dispute.
That will require, my lord, key evidence part which cannot be taken up in the repetition. So it had to go
No,
before a forum
evidence
which.
means you are the custodian of the evidence. You have to produce it before the court.
My lord.
There is nothing to be proved. These are all on paper. These are all on paper. It's a documentary evidence. Then no read would be very happy. No read we should insert. If this is the stand of the government.
That is where even one says that one is senior to the other by
But then
appointment.
that is the
They're
response.
bringing disputes
That
regarding
is the
this.
responsibility of the department. You read section 14.
Therefore, my lord, we had given out this is okay.
You read section 14. You must be knowing it by heart.
My lord. Be at page
The state level
123.
scrutiny committee shall be the appellate authority against any recommendation of the district scrutiny committee.
And the state
And the
government.
state government in the concerned area shall be the appellate authority against recommendation of state level.
My lord. So unless the district scrutiny level had recommended.
Has anybody made any recommendation?
Yes, my lord, they are challenging, if lordship will find, at page 96, the primary ground put by the petitioner in SLing the order of provincialization of service.
That is another aspect.
So already the provincialization had come up, therefore the recommendations had come up, my lord.
No. They are not challenging any order passed by district committee or state committee.
Hmm.
For prima facie, I feel subject to what he has to argue.
My lord.
Section 14 will have no application. He can be thrown out on that. On merits, you may verify that no, I am not a senior. You are senior. Every matter can go to section 14.
Process of provincialization requires the recommendation of the district scrutiny committee and the state committee.
I agree with you.
My lord, if he does not challenge the district or the state level recommendations, he would not have a case, my lord. He has to challenge them in some forum, and that forum, my lord, per section 14, my humble submission.
You come with him.
My
I have my own doubts. We want to consider this matter. Otherwise, everybody would go there. Then don't come here. Why do you come here?
district courts are a bit.
This is to be decided by you as a state government, not the
Yes.
committee. With great respect.
So, my lord, the state government.
State
Yes,
government is a
appeal
government in education department.
So therefore the appeal has to come to us, my lord.
No, why should we file any appeal? You place the material before the court. It is not an internal dispute at all. You yourself are creating the dispute by withholding the original record with you. For that, why should we ask him to file an appeal under section 14?
We produce the records, it's not difficult. How this was done.
Let him come, you are for the respondent. Pass over.
Obliged.
Why should we argue on his behalf? Let him come.
Letter number 19.
I am for the caveat, my lord, in this case. But my caveat has not been tagged with the
So,
retail.
Mohammed, you give him the copy.
Yes,
Yes, my lord. He has already punished.
My lord, I have one submission, my lord. I am the elected president of Kanai Bazar, Cow Panchayat.
He has to be heard. You can't just give him copy and be satisfied.
No, we have given already copy.
My name may kindly be, my lord.
You file your
Reflected in the
wakalat,
cause.
My lord,
file your wakalatnama or something, some note.
my lord, my submission is this, my lord, some action may be taken. Last occasion I submitted. Till the matter is heard, at least in
Has
admission
anything
stage.
happened?
My lord,
Has anything happened? Nothing.
not yet happened, but anytime may happen, my lord. Kindly, my lord, that observation may be given. Otherwise, I am elected president, my interest should be prejudiced.
15.
No further action till the matter is heard by your lordships.
Next.
the caveat may kindly be tagged, my lord. And my name may kindly be, my lord, reflected in the
Right,
cause list.
put by his name and say that the request to verify and mention the name of the name of so and so if the caveat is registered. Next.
Obliged, my lord.
Item number 20. No action, further action. Pursuant to land single judge's order. That is necessary, my lord.
It is good that
That is my legitimate right, my lord.
Mr. Mohammed, it is good that our system.
My lord,
provides
there is
that only-
violation of section 15(3) of the Panchayat Act.
Mr. Mohammed.
Not violated at all, my lord.
It is good that only judges write their orders and not ready-made orders are given.
Exactly.
Next.
Item number 20.
May it please your lordship, I pray that the matter be passed over for the timing, my lord. I am appearing for Mr. S.K. Das.
Passed over.
All right.
Next.
May it please your.
Item number 21.
This is with regard to, my lord,
That special allowance.
yes, my lord. The learned single judge, my lord, construed the special allowance to be an overtime allowance, which is in fact not the reality. Actually, the special allowance is part of our condition of service, my lord. We are bound to work 6 days in a week. And accordingly, my lord, if we don't work, then either we lose 1 day's salary or 1 day's leave, my lord. So, but the learned single judge, my lord, construed it to be an overtime allowance, and my lord, by interpreting section 59(2) of the Factories Act, concluded that it is an overtime allowance. It is variable in nature. But in fact, my lord, my humble submission and our previous case is that it is not variable in nature, my lord. It is universal to all the employees who work 6 days in a week,
Will issue notice.
my lord. My lord, interim may be considered on the next date, my lord. That may be,
That will see.
my lord.
Next.
Highly obliged.
Item number 21.
May it please your lordship. This is the case that your lordship asked me to retire Times of India regarding bank. My prayer is not constitution also says, my lord, that 2002 1 SCC 367 that the Reserve
2001?
Bank,
2001.
beg your pardon,
What are you referring to?
referring to 2002 1 SCC 367
Nikalo,
Central Bank of India versus Ravindra.
please take out.
And the Reserve Bank guidelines have got statutory force and that should be followed. My case is exactly that. It is not a one-time settlement. The Times of India, they reported that case also have got that.
Have you filed any representation under section 13(2)(a)?
Yes, ma'am.
You have filed it. Now, what is the
So,
stage of the SARFAESI proceeding?
No, my lord, they are not communicating anything. The application also, application, no, my lord, there is statutory, my lord, guideline. That, my lord, my application should be either rejected or, my lord, accepted. That should be communicated within 30 days from the date of application. They have not communicated. Therefore, thereafter, my lord.
So your case is that they should forget the recovery. That is your.
That is no, my lord, restructure.
Restructure. That's what they have to.
My prayer is restructure because you have illegally deprived me from getting the benefit as announced by the Reserve Bank of India. Because of the COVID situation, Reserve Bank had given some special incentive to the.
Now, COVID, everybody has to forget except China.
No, my lord, Reserve Bank of India has formulated special scheme for the industries.
Madam, at the most, we can ask the bank to consider your application sympathetically. Otherwise, these are all known tactics of non-payment of loans.
Not my lord, who are
what not,
sincerely
my
paying her, my lord,
But the
because of
Civil
COVID.
Council
He has
arguing
got
like-
government work. He took
You
loan.
can argue whatever you want.
Yes, my lord.
Please argue.
And government work was stopped because of the COVID situation. My
Now
liability
COVID is
also.
forgotten.
My only
Today I
claim,
also taken out my mask because it is tight.
my lord, my lord, they should have followed the Reserve Bank guidelines.
Anything else?
Yes, my lord.
Anything else?
Nothing more, my lord.
Oh.
If you want to hear the entire matter, it is your lordship. Up to your lordship.
Any other argument?
Argument too, I have not placed my case, my lord. If your lordship want to hear, that is a different thing. Otherwise, my limited prayer is, my lord, that they have illegally deprived on violation of Article 40.
You argue the matter
Yes,
on
yes,
merits. We don't stop you. You have
Yes,
to
sir.
argue the matter on merits.
Otherwise, your lordship want to dispose it of, remanding back to my lord, bank.
We
to
are not
dispose of
remanding
it.
back. We are only saying that bank may consider your application.
Consider my,
Your application which is pending. Otherwise, nothing.
yes, ma'am.
If you want a judgment, we are ready to give the judgment.
Yes,
No application is pending, Malad.
No,
I'll
no.
show from my affidavit.
This may be treated as application. What else?
No, Malad, the application for restructuring, Malad, we have considered and we granted restructuring. That I have shown in the affidavit.
That we have seen. Therefore, if at all they want to still approach, let them approach. You will get the money without recovery.
They were asked to pay a certain amount of money, Malad, as part of the
but
restructuring
why you
package.
have
No,
not
this
paid the 20%? 20%
We are not examining
of the
that.
entire loan?
What do you want, madam? Please be clear. Do you want a judgment? Then we are ready to hear you. This recovery should.
After some time, my lord, maybe given 5 or 10 minutes, I will ask the client, my lord.
You ask the client and tell
Yes,
us.
my lord, after some time.
We'll consider the
Then, madam.
judgments that you have given. We'll not pass orders without considering your judgment. You can come at 2 o'clock and tell us.
I have got some personal difficulty, my lord. I have got some
Then come.
six cases. After 5 or 10 minutes.
5 minutes. We'll recall the matter. Next.
Matter number 22.
Yes. Serial number.
My lord, the response number 5 has
3 months time, Mr. Nath.
But I told them it is on the higher side. Lordship may grant us time to, investigation has been, they are doing it. In fact, the paragraph 4 and 5 of the writ petition, it is not correct. They have not.
We don't want to examine that at this stage.
Lordship,
But 3 months time is out of question.
Lordship may at least call the matter after 3 or 4 weeks. I'll advise them to expedite the matter.
No, we are directing them. Where is the question of your advice?
Lordship.
So that if they don't do it, it will be part of the contempt proceeding. They have to do it.
In fact, they informed the police after 9 days of the incident.
But are you compensating them by that?
No.
That
No,
they are informed by 9. You want to have 9 months?
No. That has created the hurdle for us, my lord.
Mr.
Otherwise,
Nath,
Lordship.
if they really want to do, they can do it within 48 hours also.
I will apprise them, my lord. I'll apprise.
So tell them that we want the report by 22nd of December. Before we close for Christmas.
Lord.
22nd.
As your lordship, please, my lord, we will file a detailed representation and then consider. our
Or
case.
Mr. So-and-so.
Yes.
And so for the bank. By way of this petition under Article 26 of the Constitution of India, the petitioner has prayed for the following relief. The parties have taken that stand before us by way of filing affidavit in opposition and affidavit in further reply. After arguing for some time, Ms. So-and-so, learned counsel, seeks permission to withdraw the petition with the liberty to file a detailed representation. If any such representation is filed, the bank shall consider the same in accordance with law. Notice discharge, order of status quo stand vacated. Next.
Well, they may
My
file
lord,
the
there shall be
application
no order.
In the meantime, my lord, in the
Such
meantime, my lord,
representation shall be filed within a period of 1 week from today.
yes, my lord, and it should be disposed of also, my lord, the time should be given.
Next.
Matter number 23.
Disposal time also be given within 15 days or 20 days, my lord.
Yet they will do it. Why do you file it within 7 days?
All right.
Yes.
Your Lordship, that by this instant appeal, we assailed the order dated 13/7/2017, passed in WPC
No,
1319.
this is for condonation.
Yes, Your Lordship. And at the time of filing, there was a delay of 88 days, Your Lordship. So for that, we have filed IA and
That IA is pending
yes, Your Lord.
in 4 years. Who appears for the response?
Yes, I am for the response.
Do you have any objection if we
Yes,
condone it? You have objection. We will hear you on objection
Yes,
for condonation of delay.
yes,
Please tell us.
yes. Tell your lordship will find, my lord. There are additional affidavit that your lordship, earlier option, they have filed an condonation of petition. Then I raised the objection, then your lordship allowed them to file an additional affidavit. And accordingly, they have filed an additional affidavit that your lordship will find.
There are 3 paid 12.
Yes. Yes. Even a tabular form, my lord.
Yes.
Yes, your lordship will find page 12. Yes. Your lordship has seen the 13/7, the order of the Honorable High
What
Court.
do you want to convey
Yes,
or contain rather?
yes, my lord. That is the,
You have never filed appeal with delay in your career. You are a seasoned man.
yes. That's why, man,
I
would like
don't
to-
mind learning limitation law at the
Now, your lordship will have no
Pay-
explanation,
take
no
end of-
particulars,
take
no
end of my career.
letter, no materials has been placed before this court, my.
anything else.
Yes,
Anything else that you want to argue?
yes. My submission before your lordship, my lord. They have given it just a date. Just a date. Only the dates, my lord. They have said number of days they have mentioned in the tabular form, but no letter, no communication, no materials have been placed before this court. Your lordship will find. May I read this tabular form, my lord, what they have said?
No, we have read it.
Yes. Then, my lordship will find the Supreme Court decision, my lordship has seen, is giving a mere
Yes, sir, there are decisions on both these sides. Don't forget that.
that your lordship definitely.
And don't
In this case, my lord, in this case,
don't raise this issue. It is not befitting
yes,
for a party to oppose 88 days delay.
115 days.
115 days delay. Office has really taken out 88 days.
No, officers, but they have said
In their affidavit, they have said 115, but
Yes.
if you read the original record, it is 88.
88, maybe 88.
We can understand that they are bank and they are well-to-do, so we may impose some cost. Otherwise, there is nothing.
My lord, only thing, my lord, your lordship has seen this judgment. I will place before lordship, my lord. Can your lordship is giving a date, man? This is going. The Honorable Supreme Court has clearly indicated that.
That is what I am saying. We are conscious about it.
Yes.
But this is ultimately discretion of the court.
Yes, discussion. That's why I would like to.
And sir, I may tell you one thing.
Yes.
There is also a view of division bench of this court that Limitation Act does not apply to writ petitions. But we are not going so far.
Yes, but here, my lord,
Don't compel us to impose cost upon the opponent instead of imposing cost upon the applicant. It is unfair to the cause of the justice. These are all we are aware about it. What else do you want to say?
Yes, your lordship, this judgment, can your lordship will find. The para
You
29.
indicate the paragraph number.
Yes, para 29.
Para 29. Then anything else?
29 and 30.
Okay.
May I read, my lord?
No need of reading it.
Yes.
Anything else?
This is my submission. No particulars. They have not annexed anything, my lord. They have said so many letters.
Allowed. Next.
Your lordship, judgment is my lord.
We'll consider your judgment.
Yes. As your lordship.
For order.
As your lordship.
Next.
Matter number 24 and 25.
May I please, your lordship? My lord,
Yes, Mr. Majmudar.
My lord, I have received the records
can running hand. If sometimes
Beyond with it. Next. Next.
Item number 28.
Wait, survey.
Item number 29.
Lordship, in this case, office note indicate they refuse to accept the notice. Lordship. By office note dated 22/10/2022.
Mr. Kyle, most probably the company is not a running company. Most probably.
Lordship, otherwise maybe maybe allowed to publish in the newspaper. Lord.
You file an IA for that.
Lordship.
Mr. AJ Sakia appeared earlier,
Yes, Lordship, somebody's name is reflected.
but he doesn't appear thereafter.
Nobody.
And the office note says that they are not out. That is why.
But if one office note said that they refuse to accept the notice.
Next.
Item number 29.
Other side is not out.
My lord.
You are for the open.
My lord.
For the opponent.
Opponent. That's what.
What do you say?
My lord, today we filed a small objection in that matter for the next month.
You want to file?
We have filed today. Not in,
Today?
not on record.
You on vacate. Next.
Master.
Item number 30.
Made this a lot. Lordship, the IA is for delay continuation of 287 days. Your Lordship.
Who appears for the other side?
Lordship, I have already taken steps, Your Lordship. The private respondents.
You check up and tell us at 2 o'clock whether parties are out or not. Pass over. Next.
Item number 31.
Steps not taken by the applicant. Learn counsel for the applicant to take steps. David notice, service of notice. Next. Next.
Item number 32.
Yes, Doctor. The petitioner received the copy of the affidavit in opposition filed by the responsible to your author. I will communicate this affidavit and you will reply. PIL, doctor. PIL, the item 32, the commissioner has replied. The only commissioner has replied. DMC. I will communicate this reply to the petitioner and petitioner may
You
reply.
have to take some instructions in the matter.
Yes, Lordship, I have received, there are existing 8 number of vending zones, Lordship.
Yes.
And till now, the official accommodation has not started. Another round of survey is going, who is to be accommodated there. That information I have received today, Lord.
But then how to resolve this issue?
Let me come up in 1 week's time, Lordship, and on that the Lordship may pass a guideline, maybe a guideline also how to go forward with it. Whatever direction is falling from this honor.
Request of these Sakyal and Advocate in the last time. 12th December.
Not 12 December.
Yes, sir.
Next.
Highly obliged.
Item number 33.
Meet please, your lordship. My lord, this was for this contempt petition filed to comply with the agreement, my lord. On last occasion, we have filed a affidavit where we have stated that we will pay the remaining amount of 4 lakhs in the month of November and December. Today, we have given a check of rupees 1 lakh and on one check for 1 lakh rupees for 6th of December. And before 31st of December, the remaining 2 lakhs will be paid. That we have stated on affidavit. And next, so far as the flat or giving a flat of is concerned, both of us were searching for a good accommodation. Sometimes we get, see, does not choose. That is why it has taken time. Otherwise, this is not a, there is no such hurdles. Only because that comfortable accommodation has not been charged because the area she is choosing is very highly, very high cost, very posh area. That's starting from Kharguli, Ujan Bazar up to Chanmari. So, my lord, we are also searching. She is also searching. Therefore, my lord, otherwise also by so far as agreement is concerned, we are having time up to February 2023. So far as agreement is concerned. Therefore, my lord, I sincerely pray, my lord, that till at least till February we can wait, my lord, for the flat is concerned. And the money part, my lord, we have already been stated and given.
We'll keep it on 12th of December. Let us see what progress is there about whether she has received the money.
Yes. That is no issue. And my lord, may I pray, my lord, she may be little accommodating because sometimes it may not be possible to get an accommodation where we want. Because we are.
May it please your lordship. Some
In
conditions.
a lighter vein, if she would have been accommodative, then they would not have come.
Lordship, some conditions were not fulfilled. That's why this contempt was filed, lordship. Flat, the time was till February 23, but there are other conditions.
It is
that were
good that
not
we are
fulfilled.
entertaining. Otherwise, it is a decree.
Yes, lord.
File execution.
No, lordship, that agreement was made part of this
They
order.
are conscious
lordship.
about, but
This
you
order.
have also limitation.
Lordship.
You are also party to that agreement.
Yes, sir.
Therefore, please, he is making some payments. You have received 1 lakh of rupees today.
Yesterday, one check has
Yes, sir.
been given.
Therefore, we keep it on 13th December. Tell us what happened.
Obliged.
Next. Please join me.
Letter number 36.
Your lordship, this is the non-compliance with the receipt order.
Yes, Miss Devi, you will. There is
Matter may be listed next week, lordship, and on the last occasion, Mr. RTD Chaudhary appeared in this matter. So next week, lordship.
Mr. Chaudhary is not available.
He is not available, lordship. He is on leave, lordship, till 2nd of December.
Seventh, at the request of. Next.
Letter number 37.
Lordship, here I have received instruction yesterday only. Lordship, I pray for 10 days time to file affidavit, Lordship.
14th.
Final let it 14th.
Let him file affidavit.
Yes. First
Otherwise,
week of December.
let him file affidavit so that.
But
Next,
Letter number 40.
await notice. You are for item 40.
Yes, lordship.
Other side is not out.
2 and 4 is appearing, lordship.
You are
Appearance for respondent 2 and 4, my lord.
You file your vocals now.
Yes, my lord.
Next.
4 weeks time may be allowed to file affidavit.
Letter number 41.
23rd, 24th January.
Lordships, in this particular matter, I'm seeking your lordship's indulgence to address your lordships in the matter. The matter is otherwise being looked after by Ms. G. Goswami, who is has some personal difficulty in this month and in the month of December. Lordships, in the meanwhile, I have also been appointed as the standing counsel of ASALSA, and ASALSA is a party respondent in this particular matter. It's a pro forma respondent, and therefore I'm seeking your lordship's indulgence to just place one small fact before your lordship, nothing much. I hope your lordship will give me that indulgence and just hear my submission. If your lordship will kindly peruse the last order, the state government was required to place before your lordship the steps which have been taken for appointment of people in the medical health review boards. And that is the latest state as on date. And thereafter, the mental health review boards which have been placed and whether the people have been appointed. If they have been appointed, then whether they have actually gone ahead and inspected the concerned prisons and placed the report there. That is the status of affairs as of date, Your Lordships. I'm deeply obliged to your lordships.
Yes, learned advocate.
We have already constituted the boards. Now the frames are being finalized, lordship, and also the financial aspects are at the final stage of getting the approval from the finance department. So we have 2 months ago, we have constituted a board, we have already placed that instruction. So in maybe very short time, we will be able to fully functional, make the board fully functional.
Tell us by 9th of December.
Lordship.
Is it one board or you have different districts?
We are clustering the districts. Lord.
In zone, you will
Yes,
be zoning the whole
clustering.
state.
And district judges are one of the chairman of those board. Lordship.
So you are dividing the state into
Yes, Lordship.
4 or 5 zones.
Maybe I think 7, if I'm not wrong.
7.
Five.
I have the copy.
It is mentioned 5, I have read.
Five, not 7.
Yes. Initially, it was planned as 7, but ultimately we have reduced it to 5. Lordship.
9th of
In fact,
December.
after 2 rounds of advertisement, nobody came forward, Lordship, for getting their appointments. So finally, we have to nominate it.
Because yesterday probably Honorable Apex Court has also taken a cognizance in a similar way.
Maybe not. I'm not saying.
Not identical, but
Lordship.
relating to the same.
Because that act has come, so many states are not acting upon it.
Next.
Highly obliged.
Deeply obliged.
To number 42.
Yes, Mr. Nath. Mr. Majmudar, you appear?
Hello, I'm for the applicant.
Huh.
In fact, if your lordship recalls that
Lordship, kindly pass over method for the time being. My senior minister is thus selects in another court.
What is your request? You want pass over?
Yes, sir.
Pass over.
For time being.
time being,
We'll
lordship,
take up at 2 o'clock.
mine.
To number 43.
Lordship, in this matter, an action taken report was called for, Lordship. The forest part is ready, Lordship, but we are also compiling action taken by the police and the office of the deputy commissioner. So may I pay for 2 weeks more time, your Lordship? We'll file a comprehensive report.
At the request of Mr. KP Pathak, he informed the other side.
My friend is a
Lordship, I'm S. Sharma Hazarika.
Adjourned to 17th of December.
obliged.
Oh, sorry, 17th is 15th of December.
Obliged.
Next.
To number 44.
May please, your lordship. Your lordship, the matter may be adjourned for 1 week, your lordship.
January. Next.
To number 46.
APC has brought the record, the matter has to heard finally. Any date may be fixed. Preferably first week of January. Because holidays are there. Or 7th or 8th next week.
Now let it come in January. Use some date in January. Next. Next.
To number 48.
Yes.
Yes, may I please, my lord?
This is in appeal. Mr. Bora, you appear for the government?
My lord.
Okay.
अपनी अपनी है Okay. This is an appeal against the judgment passed by Honorable Single Judge in WPC number 1939/2012 on 5/8/2019, whereby the writ petition filed by the petitioner against the order of removal by the disciplinary authority was silenced. The Honorable Single Judge dismissed the writ petition on following grounds, that is at page number 120. Para number 12. These are the 4 grounds upon which the writ petition was dismissed. So
Now you were working as what?
I was stenographer in the office of the superintendent of police, not Lakhimpur. Latif. I was served a memo of charges that is a annexing my additional affidavit at page number 5. Additional affidavit, page number 5. That is first floor cause notice. You are hereby equal to.
Now, have you challenged the order passed in departmental appeal?
Yes, I did not. That was rejected. And that was rejected during pendency of writ petition.
Have you challenged that order? That is what.
No.
You have to challenge that.
Yes. I was not finding any copy of rejection, but was communicated. And that.
But now it is communicated.
Yeah. And
Challenge that if you want to.
Yeah.
Challenge the finding of the appellate authority separately.
Yes, findings.
Not findings. Have you challenged it?
No. Order of appellate order was not challenged.
Then what can be done? You have to challenge that.
Lordship, that was passed during pendency of
That
this.
we are conscious about the fact the learned single judge has said so.
So we may be allowed some time to file additional affidavit.
There is no question of allowing your time. We can close this proceeding. You challenge that in accordance with law. Otherwise, here if we pass any order, even your doors before the division bench would be closed forever. Because there is admission on your part that you accepted 1,50,000 and took loan. Now, stenographer of any authority like SP is not supposed to behave in this manner.
Lordship, what are the charges? Charges are not related.
We are not the appellate authority, sir. We are not the appellate authority. We are not sitting over an appeal or the findings arrived by the inquiry officer.
Yes, that is one of my concerns.
Appeal. You challenge that appeal order if it is in accordance with law. What do you say, Mr. Bora?
Yes. That my lord, by this, my lord, appeal order, the award of punishment is attained finality. That was not under sentence. This is the case, my lord. And in any case, he is a person working in a disciplinary force in an indisciplined manner. It is very, my lord, dangerous for the police department.
No, if a stenographer is such,
being a stenographer,
he would be dangerous for any authority.
Yes. Any authority.
The procedural irregularity as provided under Rule 9 of the Assam Services Discipline and Appeal Rules are totally violated.
Mr. Counsel, now you can't have the cake and eat it. If you want to challenge the order, go there and challenge the order.
Okay, I may be permitted to file an additional affidavit, annexing the order of.
No.
It was not a pleaded case in the writ petition.
That was not part of the writ petition.
Appeal, my appeal was pending.
We are conscious about it. Please don't repeat it. We are conscious about the fact.
You were aware that it was.
You were aware on the date on which the learned single judge decided that your appeal is dismissed. And what were your prayers in the writ petition?
Yes,
We are not here as an appellate under order 41 type of appeal.
No.
Time and again the Supreme Court has reminded us that you are not appellate authority.
Yes. My grounds are at page number 21.
We want to see your prayer.
Page 79.
Prayer in the
Writ petition. Yeah. Right from page number 68, 69, 70, 71, 72,
Prayer petition. Page 79.
79.
come to page 78.
Para 20. You can read the paragraph.
Yeah.
Para 20.
That on 26/12/2008, the petitioner preferred an appeal against the order of removal passed on 28/11/2008 by the respondent number 3 to the respondent number 2, which was received in the office of the respondent number 2 on 29/12/2008. But no communication has been received by the petitioner as to disposal of his departmental appeal. And as such, this instant writ petition has been filed.
So you filed the appeal at the time when the petition when the appeal was pending.
Pending.
Whereas one of your prayers, which was not very clear, was seeking a direction for early disposal of the appeal.
Now that order in appeal is not challenged anywhere. It has become final.
Yes, attend final.
That is noted by the learned signature.
Page 120, which you are reading. This is start before the or.
You want to challenge the appellate order. You have to file a separate proceeding. You can't bring it by way of
Additional affidavit.
the disciplinary proceedings which you have challenged. You preferred an appeal.
Yeah.
Appeal was dismissed, meaning that the findings of the inquiry officer are accepted.
Right.
Why should we as a report question those findings that the appellate authority has accepted unless we put that order to challenge?
Yes, well, you should notice at the time of motion, Honorable Single Judge passed an order. That there is no bar in disposal of the appeal preferred by the petitioner.
Correct. But that appellate disposal of the appeal resulted in an order. That order confirms the disciplinary proceeding. But that order is not necessary.
No.
So today, deciding this matter will be academic. Unless that order is before us. Perhaps at the time of hearing, at the time prior to disposal of the writ petition, you had not liberty on the court. You could have brought the order on record by way of an affidavit.
No, that has already been brought by us by way of filing an affidavit. That appellate order. So this was in the proceeding.
That was never challenged by the
No, never challenged by them. This is a question.
You are only questioning the procedural part.
No, procedure irregular.
So the appellate authority has accepted that procedure is correct, therefore your appeal was rejected. Now that particular order will have to tell it.
You can't be permitted to write 2 horses at a time. That's the question. We can do one thing, Mr. Bora and the council. In this appeal, we'll permit you to withdraw the writ petition.
With liberty to place.
No, the original writ petition which is dismissed.
Lord.
We'll permit you to withdraw with the liberty to challenge the order passed in appeal.
Lord.
Otherwise, these findings will come in your way.
Lordship. I accept it.
Because we can permit you to withdraw the appeal, even though withdraw the writ petition.
Lord.
And the appeal board.
Lord.
Lord, yes, sir. And so forth, yes, sir. Mr. R.K. Bora, learned count the respondent. By way of this intra-court appeal, the applicant, appellant, has challenged the judgment and order dated so and so. Past filed on a single judge in this petition table number 12. As per the record, while the writ petition was pending, wherein the departmental proceedings were challenged, the orders passed by disciplinary authority was challenged. The appellant had also filed a departmental appeal, which came to be dismissed. With an order dated 28/11/2008, which has not been challenged at all. Under such circumstances, the Learned so seeks permission to withdraw this appeal as well as the writ petition. You withdraw this appeal. No. Seek permission to withdraw this appeal with a preferred challenge the order passed in appellate. The appeal stands disposed of with the aforesaid report. Next.
All right. The number 49.
Serial number 49 is already mentioned by the Yes.
There, please, Lordship. On earlier occasion, Lordship directed me to file an affidavit annexing the result sheet.
Yes.
Lordship. So I have filed the affidavit, Lordship.
That affidavit is in file.
It's copy to disappear. Here we are. 7/9.
It is filed on 9/11.
Lordship. No, 7/9. That is their affidavit.
No, additional affidavit of the respondent, isn't it?
Lordship, respondent means that they are the respondent. They are I'm the appeal. This is opening the file.
The affidavit filed by Rajesh Gautam.
Yes, Lord. In the affidavit, Lordship, I have annexed Annex 1. It is page 105.
This is page
7/9.
Page number?
Page number 105, Lordship. That, that is-
105.
Yes, in my edition message. Now, the continuation of the page of the repeating.
As usual, my file is not proper.
Hmm?
Good.
49. Okay, remove this out.
There are two numbering. It is page 182. Not
Running
100.
page, Lordship.
Running page. You have to give running page.
Lordship, 105.
Hmm.
Can I get? Title of this, 1 minute title of this. Title of this.
Yes, 10.
105, Lordship.
Hmm.
That is the late fee check, Lordship, which was the respondent, Lordship, respondent petitioner. He has also deposited the late fee, page 107. Serial number 44 and 45 and 46.
Yes.
They have deposited the late fee. Also, Lordship, in the next page, there page 111, Lordship. That is the result sheet, Lordship. I have placed before your Lordship the original document, but I have made the photostat, and there is serial number second and third, Lordship. In that mark lordship, their statement is as AB, absent.
Yes.
AB, both the respondents. Means they did not appear in the examination. Now they have deposited the late fee, they have not appeared in the examination. So lordship, that's
You
why.
take instructions on this affidavit if you want to. Madam,
My lord,
you can take
They have-
instructions on this.
They have filed
no,
reply.
why it is shown absent, my lord? I have, my lord, filed my reply, my lord. Your lordship may kindly see. I filed one affidavit in opposition on 14/9/2022, my lord.
No, but absent means you have not appeared.
No, my lord. I have appeared and we appeared in the examination and we were waiting for results, my lord.
No, but see, these are all disputed question of fact. We can't decide it. The authority is saying that we rely upon the original record.
My lord, they themselves have issued the certificate. My lord, without passing secondary examination, one cannot pass.
These are all
senior
disputed
second.
question of fact.
Yes, so that is there.
We will not go into this. There is something fishy which we can't examine in our jurisdiction. Which may entail detailed examination of the fact and evidence on record.
That may be evidence of witness.
We can't examine witness that so and so was sitting beside me in his seat number was this. You have to go as per the record. If you
Your
go as per the
lordship-
record, then you are absent. Why should we go?
No, my lord,
beyond that?
we appeared in the examination.
No,
The
but
results were declared.
what proof do you have?
Your
Evidence?
lordship may kindly produce the order dated 21/2022, honorable
Let them
court
produce
order,
admit that.
where
they
my
have
lord,
appeared.
it was
That is not-
the center, the authority of the center where
That-
from they appeared in the examination was called for. And the
See,
authority.
we are
has-
satisfied with page 110 which he was showing us. There it is AB. AB means absent.
Absent.
We
My
can't overrule them and say that no, you appeared.
My lord, means the petitioner appeared and they also passed. But
Therefore,
before,
what is the evidence that you appeared? Show us.
yes, my lord, it is there. Your
No
lordship may kindly see my affidavit in opposition, my lord. I have annexed, my lord. Your lordship may kindly see at page. Corrected results are there, my lord.
You show us the result.
Yes, my lord.
Show us the evidence.
Yes, my lord, it is there, my lord. Your lordship may kindly see annexure D at page 20. Page 20 of my affidavit in opposition, my lord, of the appeal. Your lordship may kindly see at the bottom the roll numbers, my lord. 130010722257. This is the respondent number 1. And then 130010722258, respondent number 2. Your lordship may kindly see this is the corrected results and these two are their roll numbers which appear in the result provisional certificate also at page 21 and 22. Your lordship may kindly see. And the next page.
That is what we are saying. Now they have come with another result. So these are all disputed question of fact. We can't examine this in the writ petition.
That is the disputed question, lordship. We have not issued this.
Subsequently, what
result.
happened, my lord?
Corrected
Since
result.
the results were not declared, it took
there
a
is
long
something-
time, my lord. Your
something
lordship,
very
kindly
fishy.
hear me, my lord. Your lordship, they have filled up another fresh form, my lord, because they appeared in the secondary in April 2028, my lord. 2008. Then, my lord, when they were waiting and the results were not declared, and again when they found that the secondary examination of October-November 2028, my lord, the filling up of forms were going on and the last date and it was about to be closed, my lord. So they again filled up form, my lord. I have explained at my in my affidavit in opposition filed on 14/9/2022, my
It
lord.
is very difficult to examine.
In the meantime, my lord, the results were declared, my lord. Results are there, my lord. Results were declared, so they did not appear for the second time.
No, that result, lordship, we have.
Results were declared in the meantime. I have
Which result?
I have result at
Let them
annexure
follow
D,
results.
annexure D, my lord. This is the corrected result.
For the same
No.
exam, you say they were, for the same year, there were two examiners.
No, my lord. Your lordship may kindly see, one is at 2028, one examination was, my lord,
April
held
and
on
May.
April, May. My lord, in October, in November, December, and another, my lord, my lord, they again filling up of forms were going on for the next
Why they
year
have filling up,
session, my lord.
filling?
Then they found that
late fee lordship.
they will lose
One
one year,
argument
my lord.
at a time.
They will lose one valuable year, so they thought they will again fill up their form. Then in the meantime, the results were declared, and in the results, your lordship may kindly see in the letter of the which was issued from the center. This also, my lord, reflected the my lord, roll numbers of the petitioners, my lord. I have filed one affidavit, my lord. Your lordship may kindly see.
Now the result which they are
Yes.
relying upon, it was
This
declared
is
when
their own result, my your lordship may kindly produce my affidavit in opposition. They filed on to additional affidavit 28/4/2022.
report or what?
On 28/4/2022. Your lordship, I am reading this letter, my lord. This is letter. This
Madam,
letter
you
was issued from the
please turn,
center, my
you
lord.
please turn to page 192.
One ninety.
Or on 111 of the affidavit which she has filed today.
My lord, this affidavit I don't have, my lord.
Then you please have it and then argue.
Yes, my lord.
You please have it.
Copy দিব, itu নাই। না, না, এটা file করে দিতে হবে।
Now I'll tell you, you note down one date. It is 11th December 2008. When you receive that, you will find that the result was declared by the authority on 11th of December 2008.
Yes, my lord.
There you are shown with the same roll number as absent. Now turn to page 20. Page 20,
Page
which you were
20 of-
relying upon. That corrected result
Yes, my lord.
of your, which was there part of your
Annexure D, yes, my lord.
it is the running page.
Okay. What?
You call somebody from registry and get it page number serially properly in my presence. They do it doubling pagination and then it is difficult to hear the argument.
Page number of 4%.
Who is doing this in registry? Call him just now. Call that person.
One affidavit I have filed on 7/11/2022, my lord, which also clearly reflected that some communications, official communications I have annexed, my lord, clearly reflected that the petitioner appeared, my lord. I have annexed those documents with my affidavit, additional affidavit filed on 7/11/2020.
You first have the affidavit which is filed and then we hear you. Because piecemeal hearing will not serve the purpose. See now the corrected result which you were showing to us as annexure T
Yes, ma'am.
was published on which date? It is of April, May 2020.
No date.
It is, my lord, we have.
Corrected result, no date,
This is,
nothing.
Please, madam, you take your seat.
Sorry, Lord.
my lord, this was obtained online, my lord, so it did not contain any
Therefore,
date.
either of you will have to tell us which is the date because in that affidavit they have come with the date. Therefore, we are indicating, please verify that and then argue the matter.
Yes, my lord, it does not contain any
Because
date.
it is
because we have,
document submitted
updated
by you.
online.
It is not an authentic record.
But my lord, the official communications, my lord, contain date, my lord, which I have annexed, my lord, with my affidavit in additional affidavit filed on 7/11/2022. Your lordship may kindly peruse, my lord.
Additional affidavit.
Affidavit filed on 7/11/2022, my lord. Two letters I have annexed, my lord, letters issued by the
Yes. Yes.
Here, my lord, at para 2, I am reading that the department says after passing the secondary examination held in April, May 2022, 8, thereafter filled up the application form for senior secondary admission with so and so, which was received by the NIOS and was under verification by comments
No,
made on
sorry,
7
where are you reading? Which is the page number?
page number 124.
Your pagination does not tally with our pagination. That is the difficulty. You are mentioning additional affidavit
Yes, my lord.
by Prince Wazim.
Yes, my lord.
What are you reading out of that?
I am reading, my lord, at page 124, my lord.
The para 2.
Yes, my lord.
Please read.
My lord, I have annexed the, my lord, annexure also. It is here, my lord, the yes, which was received by NIOS and was under verification by comments made on 7/8/2009. This is regarding admission in the senior secondary, my lord, after passing the secondary. The relevant portion of the comments made by the NIOS authorities are reproduced below for ready reference. Your admission cannot be confirmed. Please send photocopy of original secondary mark sheet, pass certificate within 7 days. Otherwise, your admission will be cancelled and the fee will not be refunded. Subsequently, a legal notice was served to them, my lord, for seeking, my lord, the result of the secondary examination, my lord. Thereafter, my lord, the relevant for again they made a official communication dated 7/10/2009. The relevant portion of the comments made by the NIS authorities are reproduced below. Your admission is confirmed and allotted roll number so and so. So after they found that they appeared, they passed, and then their admission was confirmed.
No, now-
Your lordship,
now
annexure
therefore-
3, my lord. I have annexed annexure 3. This I am reading from the annexure itself, my lord. Annexure 3 of this affidavit, my lord. Last page.
Yes.
This is, we have got it online, my lord. Your lordship may kindly see at the comments, my lord, at the bottom. First, they said your admission cannot be confirmed. And the second, my lord, admission confirmed, my lord. So admission was confirmed only after it was confirmed that they passed their secondary examination. Without this confirmation, they would not have been given admission in the senior secondary, my lord.
This is only of one candidate?
2 candidates, my lord.
No, where is the second one?
Prince and my lord, yes, my lord. 2 documents are there. I have annexed only one, my lord. Same, my lord, similar, my lord. Your lordship may kindly see the, since I have got it from the computer, my lord. And thereafter they appeared in the secondary, senior secondary, they took admission. Thereafter they appeared in the senior secondary, they passed, and thereafter they completed LLB also, both of them, my lord. One has completed in 2015 and the respondent number 2 has completed her LLB in 2021, my lord.
Therefore, you will have to give us the date of that corrected result.
My lord.
Either of you will have to give us the date of corrected result.
Yes, my lord. We'll collect it, my lord, from the.
If you can get it online or something, the source has to be certified. Because the question is that there is word against word. Now, if you compare the roll number remains the same. Therefore, to buy your version, that second time they applied as an abandoned portion, but meanwhile they were declared passed, therefore that did not appear. And therefore they are shown as absent is incorrect because the roll number is the same roll number. Because if a person appears for the second time, his roll number is not like a savings bank account number of State Bank of India, that wherever you go, it doesn't change. If I transfer my account from Ahmedabad to Guwahati branch, my number will remain the same, only the branch will change.
Your lordship, I'll collect the date of corrected.
You will have to collect that because there has to be some authenticity to it.
Yes, my lord.
When will you be able to do it?
My lord, 2 weeks, my lord, because it has to be collected from the office, my lord.
At the
Office
request
we
of
don't
so and so.
Okay, that is why some more.
Give some date. Next.
Item number 6, pass over.
Offline.
Also, the last occasion, lordship had hard to find out a way out between the two parties. I guess we have hit a dead ball.
Please, Your Lordship. I am appearing on behalf of respondent number 4, Your Lordship. Perhaps on the last date, Your Lordship directed for a mutual settlement. Your Lordship, based on humanitarian ground, we are ready to pay an amount.
That you decide yourself. We are not.
Your Lordship. Lordship, coming to, if we go by the provisions of law, Your Lordship, as per directed by the Honorable Tribunal to pass a speaking order, Your Lordship. The Lordship, in the speaking order, if Your Lordship may kindly peruse to page 62, Your Lordship. It has been directly reflected on the last para. May I read, Your Lordship? Regarding the claim of the applicant for providing pension or settlement dues of her son, it is stated that as per extant rule, the wife of the deceased has the first right to receive pension and other benefits. Moreover, in this case, the son of the applicant has died in the year 1987, Your Lordship, back in the year 1987, and settlement dues were paid to her by her wife, Srimati Ratnakar, the respondent number 4, Your Lordship, at that time, and it is not possible on the part of the railway to apportion that amount at this distant date, Your Lordship. And Lordship, as Your Lordship kindly perused the order passed by the Honorable Tribunal, Your Lordship, the main fact is that there are category of judgments where it has been said that, Your Lordship, simultaneously 2 pensions cannot be claimed, Your Lordship. Now they are asking for a part of the pension from the respondent number 4, which I am getting from my husband, Your Lordship. Now the thing is that the claimant is already, the petitioner, present petitioner is already getting an amount of rupees 3,747 as an ex gratia through SB account number 242199. Only on this ground, Your Lordship, their whole claim was dismissed on this ground that 2 simultaneous pensions cannot be claimed, Your Lordship. That is my humble submission before your honorable court.
You try to settle the issue. Ultimately.
Lordship, on humanitarian ground, I am ready to actually, Lordship, the real fact is that the present petitioner is almost 81 years of age. She is on a deathbed. We are ready to pay her on humanitarian ground, but everything is pursued by the grandson, Your Lordship. And now there is a tussle between the grandson and the family of this present respondent number 4. So when we go to pursue them, they do not entertain us. That is the main problem, Your Lordship. Otherwise, on humanitarian ground, to a lady of 81 years of age, you are ready to pay.
Oh, both of you can sit together at least.
Lordship.
At the joint request. Next.
Lordship,
when will you be able to tell us? Mr. Ahmed, you sit with the council and try to hammer out some solution.
If it's possible, the High Court itself.
High Court itself.
Yes, sir.
When should we keep the matter?
Just to the better because the vacation is approaching.
When do you want the matter?
Lordship, perhaps right now the respondent number 4 is out of station as due to some as he's suffering from some
Which date do you
difficulties. Your
want?
Lordship, somewhere in the first week of January, Your Lordship.
18th of January. Next.
Obliged.
Much obliged, Your Lordship.
To explore possibility of any amicable solution. Next.
Much obliged, Your Lordship.
तो पता एजिनेशन डबल हो गया है करवा लो बिटा के हाँ तो बता देना ना ये यहीं पे पेट पे करवा दे डबल हो गया है एजिनेशन देखो एजिनेशन डबल हो गया है चेंज कर यस मिस्टर मजमूदार
Item 42, my lord. My learned friend is appearing for the respondent.
Meetings are otherwise complete, my lord. They have also filed, we have also filed a replies. My lord, can take it up for disposal. Many other date, my lord, if not otherwise inconvenient.
You tell us.
Well, next week, my lord, it's not otherwise
No,
inconvenient.
next week we are already. Now keep in mind, Mr. Nair and Mr. Majmudar, time to write the judgment also. Now that time has come for me to watch that.
And this will actually require a prolonged hearing.
Therefore, we
have understood.
I always believe in reality in life.
Right.
Understood.
Lordship may for Lordship may keep it in the first week of January. Let us keep it.
First week of January, virtually it would be a notional.
Notion. My lord, let it be then after, my lord,
Yes, sir.
17th that week, my lord.
In my short tenure, I have hardly seen you appearing in any service matter, Mr. Majmudar. Mr. Nair can understand notional.
My senior is a now because he's in the other side.
I know that. I know that also. So it would be a notional date.
My lord, we'll have it after 16th, but any day.
We do one thing, we'll keep it on 9th
Lordship,
as a notional date. Then we'll fix up as per your choice.
Lordship, my lord, Lordship, Lordship,
The joint request taken to 9th of January.
Lordship. Much obliged.
So I can have benefit of your presence of both of you.
Lordship, we are here. Much obliged.
Item number 16.
May I have my lord?
Yes, sir.
I am appearing for the appellant, my lord.
Yes, sir.
My lord, there is appeal, my lord, against the order of removal, my lord.
Yes, sir.
Although, my lord, Singh has considered the matter, but the only point is that, my lord, the proper opportunity of hearing was not given, my
lord. By whom?
By the disciplinary authority, my lord. Because, my lord, he was only once appeared and admitted his guilt for unauthorized absence.
And what the DP was proceeded.
In some cases, once is enough. In some cases, once is enough, counsel.
And my lord, also my lord, that is procedural lapses. No presenting officer, nothing, no defense was provided, my lord. And that was
Did you ask for it and it was declined?
No, my lord.
Then once you accept it, accept the contention, what inquiry would be required?
But my lord, DP was proceeded. So, my lord, procedure is to be.
Turn to page 102
Yes, my lord.
and read para 23 and 24.
Yes, my lord. 23, my lord. In the backdrop of the law laid down and the principles governing the aspect of the judicial review, let us examine the facts of the instant case. Though the scope of only to examine the decision-making process in the instant case, the records clearly shows that the misconduct has been admitted. And as indicated above, even in these proceedings before this court, there is no denial the petitioner in the pleadings of such admission of misconduct. In that view of the matter, is actually not required to go into the merits of the decision. However, to do substantial justice under Article 226 of the Constitution of India, the following aspects would also be relevant. Next, the church is of unauthorized absence, which may appear to be innocuous. However, each church has to be examined vis-a-vis the employment of the delinquent. In the instant case, the petitioner was serving as a constable in the Railway Protection Force, which is undoubtedly a disciplinary service. Apart from the fact that unauthorized absence is a major offense prescribed under Section 147 of the rules, even otherwise such indiscipline from a personnel of the Railway Protection Force cannot be overlooked. Moreover, the present case, as indicated above, is not the first instance of the unauthorized absence, and on many other occasions, the petitioner said indulged in the same misconduct. And on this,
I think earlier 3 occasions.
Yes, ma'am.
As per the record.
Yes, ma'am.
Now read further.
Occasions, penalty was imposed upon him. Viewed from this aspect, the imposed penalty does not appear to be unjustified. This court is now required to deal with the argument regarding opportunity of the penalty imposed, proportionality of the penalty imposed vis-a-vis the nature of the church. There is no manner of doubt that the doctrine of proportionality is a well-recognized doctrine which comes into the play during exercise of judicial review of an order of penalty imposed in a disciplinary proceeding. The requirement is that the penalty imposed is such that it shakes the judicial conscience. Judicial conscience, just a position the church level even on its face value. In the preceding paragraph, it has already been discussed that the present case is not the first instance of the petitioner being unauthorizedly absent. On 3 earlier occasions,
and
penalty was imposed upon him.
Counsel, he was absent for how many days?
He was absent for my lord.
Rather years.
More than yes, my lord, more than 1 year.
More than 2 years. 672 or 73 days. 74 days, almost 2 years. Little less than 2 years.
So my prayer is that my lord, he served for more than 15 years.
Maybe.
Compulsory retirement.
After 15 years, he has remained absent for 3 years.
Compulsory retirement is also major punishment, my lord. That may be converted into compulsory.
This is not a criminal appeal that we convert 302 into 304 part 1 and 2.
So that is my prayer, my lord.
Nothing can be done, sir. There is nothing. So your only argument is that you are not properly heard.
Yes. No other argument. Disproportionate. These are the two arguments.
Yes.
Heard Mr. S. Nath for the appellant. For order. For order.
Yes.
Next.
Question number 18.
For orders on Tuesday, liquor. You are leaving next. Tuesday. Serial number 18. That Majmudar was there.
Yes, sir.
How do you say that it is covered by section 14? That was the question.
Well, he's against the provincialization of the response number 7.
We will admit it. Admit for hearing. To be listed in the week beginning from 23rd of January 2023. Next.
Available.
Question number 30.
Next is about.
In fact, similar connected matters have been disposed of.
So,
matter has become instructed.
Learned counsel appearing for the appellate states that connected writ appeals being writ appeals number 21/22 has already been dismissed, and therefore the cause ventilated in the appeal would not survive. In view of the aforesaid, the application for condonation of delay is dismissed. As the appeal is dismissed, or as the condonation of delay application is dismissed, the appeal would not survive. The same also stands dismissed. On the same reasoning as for the judgment of the coordinate bench of this court rendered in WA 21 of 2022 dated 4/2/2022. Next. Board over. Oh, will go ahead. 6:30. Inform Chaudhary sir. Chaudhary sir, who else is there? Chaudhary. वो जो अभी आप आर्ग्यू कर रहे थे वो फाइट पे तो वो बता जाए आज इसका लाभ ले ले, मेरे हाथ में नहीं आए।